Hey everybody. Today I'm going to go over the third and final PowerPoint for Unit 4. This is probably going to be pretty lengthy and detailed because I'm going to be tying a lot of prominent Supreme Court cases throughout U.S. history to certain not articles, amendments in the Constitution, specifically the Bill of Rights, but also other amendments as well outside of the first 10, the Bill of Rights. All right, so the first one, you could make the argument this is the most important Supreme Court case in U.S. history because it established judicial review, which is the power of the Supreme Court to decide whether or not laws, actions of Congress, are constitutional or not. So don't get bogged down in the details of it. I just want you to always associate Marbury v. Madison with judicial review, giving the court the power to decide whether or not laws are constitutional or not. Okay, so that's the big thing to take away from Marbury v. Madison. All right, next one, McCulloch v. Maryland. Once again, I don't want you guys to get bogged down in the details of this. Just know that the precedent that it set was that states cannot tax the federal government, and it established the supremacy of the federal government over all state governments because the state of Maryland tried to tax the first bank of the United States, and the Supreme Court said, no. Supremacy Clause, Article 6 of the Constitution, states cannot tax the federal government, supremacy of the federal government over the states. All right, next one, Dred Scott versus Sandford, arguably the most detrimental and immoral ruling that the court has ever made. Essentially, a slave named Dred Scott traveled to a free state with his owner, and according to that state's law, that free state's law, as soon as any slave crossed over into that state's over that state line, they were considered free. And so Dred Scott sued his owner and said that he should legally be free according to that state law. And the Supreme Court ruled in favor of Sandford, the owner, saying that slaves cannot sue in court. In fact, I don't know how it even got this far because slaves are not people, they are property. So first of all, yikes, that's horribly racist. Second of all, we can't deprive the owner of the slave their Fifth Amendment due process because we can't strip them of their property. All right, so that kind of ties in with eminent domain in the Supreme Court ruling there. All right, you'll learn more about Missouri Compromise next year. It ruled that was unconstitutional and that slaves could not sue for their freedom. Just know that this set a terribly racist precedent in U.S. history, and like I said, you will see Dred Scott v. Sandford again in more of a U.S. history context. All right, next, Plessy versus Ferguson. If you were going to say besides not Brown v. Board, besides Dred Scott v. Sandford, what might be the most immoral Supreme Court ruling ever, you could say Plessy v. Ferguson. For that, the issue at hand here was equal protection under the 14th Amendment, which, remember, granted all former slaves citizenship and also established birthright citizenship as well. So there was a black man named Plessy, Herman Plessy, which really he was not even fully black. He was 1/8 black. Not that should matter, but it's just interesting. He sat in a rail car in the South designated for whites only, and he was arrested and he sued. And the court said, the state of Louisiana is right. This is not ruled a violation of the Equal Protection Clause of the 14th Amendment, and it set the precedent of what is known as separate but equal. Separate but equal basically gave all the government, federal and state, the right to segregate people based on race, saying that as long as the accommodations were separate, however, if they were equal, it doesn't matter. But as we now know, separate is inherently unequal. If you're going to separate people based on race, that is inherently unequal. There's no such thing as separate but equal. And eventually this will be overturned. We'll talk about that one later. All right, Schenck v. U.S. All right, this is dealing with the First Amendment. So there was this man who was a communist in the U.S. He was circulating a flyer during World War One, telling people to dodge the draft. If you get drafted, you shouldn't have to go serve. Okay, and he was arrested under a law that was passed just a couple years prior called the Espionage Act, and the court ruled in favor of the government, saying that in times of war, the government can impose certain restrictions on free speech if it is during a time of war. If there's a clear and present danger and there is a security threat in the nation. So people, ardent supporters of civil liberties, look at this as a negative because it limits free speech. However, the government in this case was given the right, according to the Supreme Court, due to the clear and present danger, quote unquote, clear and present danger of the situation here. All right. Next one, Korematsu versus the United States. Another very sad ruling. This dealt with the 5th and 14th Amendments, also during a time of war, this time World War II. So during World War II, President Roosevelt issued an executive order placing all Japanese Americans in what were called internment camps along the West Coast. These were not death or concentration camps like what we think of with what the Nazis did to the Jews and other quote-unquote undesirables in Nazi Germany and Nazi-controlled countries. But this was absolutely immoral and racist. There's not really any denying that. Because people were being discriminated against just because how they looked and where they came from originally. And so there's this man named Fred Korematsu. He was Japanese American, and he said this is illegal. The government should not have the right to do this. And the court ruled in favor of the government, similar again to Schenck v. U.S., said that if there is a clear and present danger or threat to the United States, which, think back to Pearl Harbor and all the hysteria of against Japanese because of the attack on Pearl Harbor, the Supreme Court gave the federal government the right to do this, which is certainly a sad point in U.S. history, but it happened nonetheless, and we should know about it. All right, so to a more inspiring, good Supreme Court ruling, Brown versus Board of Education. There was this young African-American girl in the city of Topeka, Kansas, who was having to walk 7 blocks to catch a bus to her segregated all-black school. However, there was a school within 6 blocks of her home, which was an all-white school. And the father, man whose last name was Brown, he sued the Board of Education, saying that this is ridiculous. My daughter should not have to be walking 16 blocks to catch a bus. Should not have to walk 7 blocks. Sorry, not 16. I don't know where I got that from. Should not have to walk 7 blocks to catch a bus whenever there's a school within 6 blocks of this house. It's ridiculous. And so, luckily, over the years, the times have changed enough that the Supreme Court said, absolutely, separate but equal is ridiculous. Separate educational facilities are inherently unequal. If you're separating based on the race of people, that's unconstitutional. So this overturned separate but equal of Plessy versus Ferguson, and this started the process of integration within not only schools but all public facilities within the United States. There absolutely needed to be more. There was absolutely more to be done on this. That needed to be done on this, and eventually in the 60s, more important civil rights legislation was passed as well. All right, Mapp versus Ohio. Mapp versus Ohio is an interesting one. I'm going to try to be as professional as I can about this, but it's very interesting. And if we were in class in person, I would, I try to make this as interesting as possible because this is one of the more crazy Supreme Court cases. But it deals with illegal searches and seizures, which is protected under the 4th Amendment. So there's this lady whose last name was Mapp in the state of Ohio, who was accused of harboring a fugitive. So police showed up and said, we need to search your home. And she said, no, I'm not going to let you do that. You need a warrant. Police came back later without a warrant, broke into her home, and did not find the fugitive. However, did find explicit content, which at the time was illegal to own. And so she was arrested for this, convicted, and then she said, "No, this doesn't seem right." And so she sued, and it went all the way to the Supreme Court, and the Supreme Court ruled in favor of her, saying that you cannot acquire evidence illegally and then use that in a court of law to prosecute somebody. So this ruled on behalf of the defendant, and she was let go. So there you go. Interesting little fact for you. All right, next one, Engel versus Vitale. Issue at stake here is freedom of speech, freedom of religion, and separation of church and state. There was a school in New York that was requiring students to recite a prayer at the beginning of the school day. Some parents said that this was unconstitutional, that, there's a separation of church and state. The school should not be requiring students to pray. And they sued, got all the way to the Supreme Court. Supreme Court said, yep, you're right. This is a violation of the Establishment Clause in the Constitution because it was being recited in a public school. So the precedent set is that school prayer is unconstitutional. Important to note that this does not say that people cannot pray in school. This says that the school cannot make students, or staff for that matter, cannot make them pray. Okay, so important to note. All right, next Supreme Court case, Gideon versus Wainwright. So this was dealing with the 6th and 14th Amendments. There was this man named Clarence Gideon. He was arrested for burglary, and he was a very, very poor man, and he was not given a public defender. So you know how if you cannot afford an attorney, one will be appointed to you, right? Was not the case here. He was not given a public defender, and so he had to represent himself in a court of law, which seems a little wrong. So the Supreme Court said, "Yep, Gideon, you're right. Florida had violated your 6th and 14th Amendment rights, and so." The precedent set here was that people who could not afford an attorney must be provided a public defender in all felony cases. And afterwards, they retried the case. He was given a public defender, and he was ruled to have not committed the burglary. So pretty neat for him. He helped usher in, even though he was not a Supreme Court judge or anything. He helped usher in a very, very important ruling, which set a very, very important precedent of being afforded a lawyer if you can't afford one. So pretty neat story there for Clarence Gideon. Hold on 1 second. I think I might. Yeah, here we go. Escobedo versus Illinois. We're just gonna skip this one. All right, Heart of Atlanta Motel versus U.S. All right, so on the table here was the 5th Amendment. Interstate commerce and segregation. So this was during the height of the civil rights era. There was a motel that was suing the government over the Civil Rights Act of 1964, basically saying we should be able to discriminate against serving Black Americans. Court said, nope, Civil Rights Act of 1964 says that is unconstitutional, and we say that the Civil Rights Act is constitutional. Therefore, you have to serve people and cannot discriminate based on race. All right, Miranda v. Arizona. If you have ever heard of the term Miranda rights, this is where it originated from. There was a man named Ernesto Miranda who was accused and arrested of kidnapping and rape. He confessed to the crime. However, he was not read his constitutional rights before being interrogated. So he appealed the conviction, saying that the police had violated his rights by not informing him that he had rights. And the Supreme Court said that is true. The police have to inform accused criminals of their rights. And so this is where the term Miranda rights come from. So whenever you are arrested for something, you have to be read your rights. You have the right to remain silent, all that stuff. All right. Important precedent set there. All right, next up is Tinker versus Des Moines. All right, so this was the issue at hand here was First Amendment, freedom of speech and expression. So there were 3 students, you can tell here in 1969, this is the height of the Vietnam War, who wanted to wear black armbands with peace signs on them protesting the Vietnam War. These students were told to remove the armbands. They refused and then were suspended from school. So they sued, went all the way to the Supreme Court, and the Supreme Court said, the students have the right to freely express themselves in school. So the school needed to show that a reasonable disruption was being caused to the learning environment, and they couldn't because it wasn't causing a disruption. And so the precedent set here was that unless you can show a reasonable disruption in school, students should be able to freely express themselves. All right, next up, New York Times versus the United States. This was another First Amendment case, but this time dealing with the freedom of the press. So during the Vietnam War, the Pentagon put together a paper outlining how they made decisions, the Pentagon, the Department of Defense, the president, so on and so forth. This document was leaked to the New York Times and the Washington Post. The New York Times began publishing the findings in their newspaper, but the government filed an injunction saying that they should not be printing this. That's it's what am I trying to say here? Good Lord. It was a national security threat. There we go. That's what I was trying to say. So the New York Times sued and said, no, this is freedom of the press. We should be able to do this. The Supreme Court said, yes, the New York Times, you are correct. It is the right of the paper to print this material because it was given to them in a legal manner. All right. So precedent set here is that prior restraint is unconstitutional. The government must be able to prove that a clear and present danger was in effect. They were not able to. Therefore, the Pentagon Papers were released by the New York Times and the Washington Post. There's actually a really good movie about this starring Tom Hanks and Meryl Streep that came out a few years ago. It's called The Post. There you go. So you can go and watch that if you want to. Next up, Furman v. Georgia. Nah, we're going to skip that one. Roe v. Wade. All right. Very timely, very important court case here. In 1973, this court case was decided. The issue at hand here was the 9th and 14th Amendments. There was a court case that said that women could not have an abortion unless advised by a doctor. A woman who was using an alias named Jane Roe filed a class action lawsuit saying that was not legal. The Supreme Court ruled in her favor, saying that states cannot pass laws banning abortion. And so important precedent that was set. There's a lot of talk about this nowadays, especially with the Supreme Court seat being open, about whether or not this might eventually be overturned. So who knows? Keep an eye out for it. All right, U.S. versus Nixon of 1974, another really important case that set a really important precedent. The issue at hand here was the separation of power and checks and balances within the United States, which is not necessarily an amendment, but that is absolutely in the Constitution. So during the election of 1972, a group of people working for the committee to re-elect the president, that's Nixon, broke into the Democratic National Committee headquarters and were trying to bug the place. Over time, it was shown that President Nixon had helped hire them, and the courts issued a subpoena for Nixon to turn over audio tapes that he had, which showed that he was being guilty. That he was guilty and he was acting in this ploy. He said he did not have to turn these over because he's the president and he didn't have to. That's executive privilege. The court said, does executive privilege exist? Yes, it does. However, in this case, the privilege does not apply because this is not a matter of national security, but it is illegal to do this, and so precedent said is that yes, executive privilege does exist. However, you must show that it's a threat to national security, which was not the case here. So Nixon eventually turned over the tapes. He resigned, the only president to this day to resign from office, and then Gerald Ford took office. All right, we're going to skip Greg v. Georgia again, and we're going to skip UCal v. Bach. All right, New Jersey versus TLO. All right, so this is dealing with Fourth Amendment illegal searches and seizure, but this is relevant to y'all because this happened at a school. So someones with the initials TLO was accused of smoking in the bathroom at a high school. She denied that this was going on, and her purse was searched. School officials found cigarettes, rolling papers, marijuana, numerous things of the like. She appealed her expulsion from school on the grounds that her Fourth Amendment rights, illegal searches and seizures, stuff like that, probable cause, had been violated. The court said that the school is right in this case because they needed to keep guns and drugs out of school, and this created a situation where school officials had to have broader powers. So the precedent set here is that reasonable suspicion can give school officials the right to search certain property that belongs to students. All right. So if there is a probable cause that someone is either going to be a danger to themselves or to someone else, school officials, probably administrators, they have the right to search. Because I know for a fact, if I was a teacher and I was afraid of someone harming themselves or someone else, I would not do the searching, but I would, relay that to the higher authority who may use that privilege to search a student's belongings. All right, Bethel School District v. Frazier. This one's really clever and it's kind of funny. However, it is important too. This was a Supreme Court case dealing with freedom of speech in school. So there was this student named Matthew Frazier who was giving a speech endorsing a classmate of his for some elected office in school, student council presumably, or class president, something like that. During the speech, he was making very explicit metaphors, and the school suspended him for this. Did not let him speak at graduation because he was elected to speak at graduation. And the school said, no, we're not going to let that happen. Not after this happened. And so Frazier appealed his ruling, based on freedom of speech in school. The school said that, or sorry, not the school. The Supreme Court said that the school is in the right here. They can ban certain speech if it's, showing a reasonable disruption to the learning environment. So similar to Tinker v. Des Moines. However, this time the Supreme Court ruled on the side of the school. All right. Next, Hazelwood School District versus Kuhlmeyer. Another similar First Amendment case here. However, this is dealing with freedom of the press, not speech. There was a group of high school students who filed suit against a principal in the school system because they had deleted an article that these teenagers wrote about teenage pregnancy and divorce from their school newspaper. And the Supreme Court said that the school, and specifically the principal, was in the right here because they can edit school newspaper material that they find inappropriate to maintain the educational environment. So kind of that disruption of school thing again. And so once again, this kind of gave principals and school districts a little more leeway in terms of what they can and cannot censor. All right, and lastly, Texas v. Johnson. This is in 1989. This is dealing with freedom of speech and the First Amendment. In 1984, President Ronald Reagan was running for re-election, and the Republican National Convention was being held in Dallas, Texas. There were a group of protesters there protesting the president and his actions on certain things. There was a man named whose last name was Johnson who set fire to an American flag and was arrested for it. And he said that should not have happened. That's me expressing myself, freedom of expression, freedom of speech. Court ruled in favor of Johnson, saying that people absolutely have the right to burn the flag if they want to. You may not agree with it, but that is a right that you have. And so flag burning was protected by the First Amendment, freedom of speech, and freedom of expression. So that is another important Supreme Court case that ties in with important constitutional amendments. So that is it for the PowerPoint. Like I said, I know that was a lot of information, but these are just Supreme Court cases that had set very, very important precedents, were tied to important amendments in the Constitution, and I think that all students should know about. So thank you for listening and watching, and have a good day.